What's up, guys? Brian Fell, Law Group PLLC here with your Florida Law Weekly Case Update. Hope everybody's having a wonderful, terrific Tuesday. 5 cases for you this week. First one is Healy versus Healy. It's out of the 4th DCA. Interesting one where shared parental responsibility was temporarily changed to sole parental responsibility. So what does that mean regarding the parenting plan's provision that says that the parties have to have the child go to school in a certain county? Here it was St. Lucie County. Parenting plan says the parties agree that the child will essentially go to school in St. Lucie County. Well, during a time when the mother was granted sole parental responsibility, temporary sole parental responsibility, she changed the child's school. And the father went back and said, hey, wait a minute, we agreed in the parenting plan that the child would go to school in St. Lucie County, I think it was. Well, the appellate court said, not so fast, my friend, because the fact that the mother had temporary sole parental responsibility meant that during that time where she had temporary sole parental responsibility, she could make all the decisions that she wanted with regard to the child. So that's a super powerful thing to have, sole parental responsibility, even if it's on a temporary basis, because the mother was permitted to change the child's school during that time, regardless of what the parenting plan said and what the parties previously agreed to. Next case is Niemeyer versus Niemeyer. It's out of the 3rd DCA. This is an interesting case that involved a anti-suit injunction. Not something that you see very often in family law cases, but it's something to have in your toolbox if you're a lawyer and you have an international case, if you have some sort of UCCJEA, Hague Convention, international jurisdictional battle. In this case, the jurisdiction was in Turkey. And so basically the parties lived here in Florida, in Miami, in the United States. And of course, right after they break up, the mom takes the child back to Turkey and she files an action there in Turkey. And for some reason, the Turkish court said that Turkey was the home state of the child, even though I think it was undisputed that the child had not lived in Turkey for more than 6 months. So I don't know how that happened exactly. But anyway, the father tried to file a anti-suit injunction here in Florida, which basically would prevent the mother, because the court here had jurisdiction over the mother. And so it would prevent the mother from filing suit and proceeding with her suit in Turkey. And they went to a non-evidentiary hearing where legal argument was made. And apparently the trial court was not convinced because, among other things, the mom had put in her answer to the petition that Turkey had said that it was the home state of the child. Even though that may not be factually accurate, there was an order from Turkey saying that it was the home state of the child. So the appellate court said, on these specific circumstances of this case, we're not going to allow the anti-suit injunction, but it's without prejudice. So the father could have an evidentiary hearing and maybe present more information to get some sort of pickup order for the child. But something to consider. Anti-suit injunction, don't forget about it. Next case is Levinas versus Levinas. This is out of the 3rd DCA. This is a very important case for people when you're drafting an MSA. So the MSA in this case basically said that the husband was required to pay for the mortgage and the carrying costs of the mortgage and the related expenses so long as the wife's name remained on the mortgage. And he was also entitled to receive all rental proceeds. This was a rental property. So he was entitled to receive the rental proceeds under the MSA, and he was responsible for paying the mortgage. So what happens is eventually the house gets sold, and the husband says, well, hey, I'm entitled to credits for the mortgage payments and the carrying costs that I paid after the parties got divorced. And so you might be thinking, well, but wait a minute. You said in the MSA that you were responsible for paying the carrying costs and you would receive the income from the rental proceeds. Well, the appellate court said, if you don't specifically say it in the agreement, then common law or Florida law applies, and when parties get divorced, they jointly own property. It's no longer tenants by the entireties. It's no longer joint tenants. They become tenants in common, and each tenant in common has a right to essentially reimbursement, compensation for the expenses that they pay on the mortgage, the carrying costs and those related expenses. They're entitled to compensation and reimbursement upon the sale. And so that's basically what happens. So be super careful if you're writing that MSA. Make sure you put in there, that the person that's paying the mortgage, if you're representing the other person, say that they're not going to get any credits for any offsets or anything like that upon the sale of the property. Got to be super careful on that. Next case is a charging lien case. This is for all the lawyers out there. Very important as well, because we all see people file charging liens. Lawyers file notice of charging lien in the case right after they get out. You got to be really careful as a lawyer. You have to protect that charging lien that the other lawyer filed, because if you have notice, and all it takes is notice to perfect a charging lien, not protect, to perfect the charging lien. All you need to do as the lawyer that's getting out of the case, you just have to file notice of charging lien. Then everybody is on notice that you have a charging lien, and they have to protect your charging lien, meaning they have to notify you and take any sort of reasonable steps to make sure that you're going to get paid, or at least put the money that you're allegedly owed, put that in trust, set it aside, make sure that it doesn't get squandered. Because in this case, this is not a family court case, but I think it would apply anyway. Basically, the former plaintiff's lawyer put everybody on notice for the charging lien that the plaintiff's lawyer, needed to get paid from the settlement proceeds, and the other people were on an email chain, and they basically said, "Oh yeah, we'll make sure that your name is on the check," and things of that nature. But that didn't happen, and so what happened was the plaintiff, after the defendants paid the settlement, the plaintiff took the money and ran, and never to be seen again, could not be collected against, and so the former lawyer sued the new lawyers, the current lawyers that were involved in the settlement, and the former lawyer won on appeal, and the appellate court said that the new lawyers are responsible to pay all of his fees, jointly and severally responsible with their clients, because they did not take reasonable steps to protect this guy's charging lien. So super, super careful. You don't want to get sued by the former lawyer in the case if you fail to protect the charging lien. Last case is Said versus Bell. This is out of second DCA. This is very important also when you're drafting a settlement agreement, marital settlement agreement. Make sure that if you're trying to make something lump sum alimony, make sure it's really lump sum alimony and it's in the nature of support. It's alimony. Because if you label something as lump sum alimony and the court finds that it was actually, in order to equalize the parties, it was actually equitable distribution, it's not going to be enforceable by contempt. And in this case, it appears to say that even if you say this is enforceable by contempt, the court is going to look at the substance of the agreement and say, was this a property settlement payment for equitable distribution, or was this support related for alimony? If it's support, enforceable by contempt. If it's equitable distribution, a settlement payment, it's not going to be enforceable by contempt, because here in the United States, you can't hold people in contempt for regular debts. There's no debtor's prison, right? So you can't go to jail for that. You can't be held in contempt for failing to pay a regular property settlement payment. Otherwise, you have, if you're the person that's owed the money, you basically have the rights as any other creditor, as if you had a judgment against somebody in a civil case. So if you're going to draft that settlement agreement, make sure it's kind of clear that this is a support-related payment. This is alimony. This is not a settlement for equitable distribution, otherwise not enforceable by contempt. All right, guys, I hope everybody has a wonderful week. Look forward to seeing you guys in a little bit. Take care.